IPR cell of KLE Society's Law College, Bangalore. It gives me immense pleasure to welcome you all to the first lecture of the IPR webinar series 2021. I take this opportunity to welcome our first resource person, Dr. M.K. Matoli, Faculty of Government Law College, Hassan. I also welcome our principal, Dr. J.M. Mallikarjunaya, our academic coordinator, Dr. Anita M.J., our IQAC coordinator, Dr. Manoj Kumar V. Hiramat, the coordinator of our cell, Ms. Rashmi R., all my fellow colleagues, and most importantly, all my dear students. It is with great pleasure that I take this opportunity to introduce our esteemed resource person, Dr. M.K. Matoli. He is an MA in economics, an LLM, and a PhD in law. He has been teaching since 1995 and has teaching experience of more than 25 years. His areas of specialization are IPR, corporate laws, laws of evidence, international trade laws, and personal laws. Dr. Matoli has served as principal of Government Law College, Hassan from the year 2012 to 2018. He has acted as a master trainer in judicial training programs organized by the Karnataka Judicial Academy, Bangalore, and KHPT on the rights of marginalized women. He has also delivered more than 80 special lectures for state government employees on POCSO in 2017. And these are just a few of the many feathers in his cap, and we are extremely grateful to have you with us, sir. Before we begin, I would request Ms. Rashmi R to give us a brief about Navodhava and talk about the webinar series. Over to you, ma'am.
Thank you, Simona. A very good morning to one and all present here. Navodhava, the IPR cell. When the word Navodhava was coined way back in 2018, it was a complete zeal for all the faculty members and the students who were initially involved in constituting this cell of IPR. We intend to disseminate the vast knowledge of intellectual property rights and also to create awareness and to help students and the legal fraternity, especially the academicians, to protect their intellectual properties. The cell Navodhava, IPR cell of KLE Society's Law College, were established in 2018, October 13th. The cell is committed with the objective of enhancing the IP knowledge and research capabilities among the students, researchers, academicians, and various stakeholders of IP industry. This cell, right from the 2018, the very date of its inception, has involved in itself in conducting several activities of intellectual property rights. Even in the hard times of COVID, we did not stop the activities of the cell. We conducted an international webinar on patenting of life-saving drugs in the context of the pandemic. Apart from that, the cell has been actively conducting the workshops on IPRs, especially issues with respect to patenting and practice procedures, and national level IPR quiz have been conducted to encourage students to involve and to know much about intellectual properties. About this IPR webinar series 2021. This webinar series has been designed with 12 different lectures of intellectual property rights topic. And this webinar series mainly intends to help the students to understand the various basic concepts of various intellectual property rights and to also help them to face the KSLU examinations effectively in the coming days. We have, when we contacted teachers from different colleges of KSLU, they were very happy to accept the invitation and to support us in starting this first experimental event to organize a webinar series on subject specific and topic specific and syllabus specific in nature. We have contacted very well-known teachers who teach IPR in various law colleges under KSLU and also very well-known practitioners of IP. I just give you the brief of the topics which will be deliberated by the resource persons in this 2020 webinar series. The first speaker, Dr. M.K. Matoli sir, faculty from JLC Hassan, Dr. Pramat Adiga sir, who has joined us, faculty from Shri College, Shri Raghavendra sir, advocate, High Court advocate in Bangalore, Dr. Balika Madam from SDM, Ms. Suhasini, the founder partner of IP attorney at Lex Novet Legal. We have Dr. Rekha Chavan Madam from GLC Hassan. We have Mrs. Gayatri Bai, faculty from Jeshadripuram Law College. Shri Prasanna Bhagavan sir, again practicing IP and a technology lawyer from LexNovate Legal. And we have Dr. Santosh Prabhu sir from SDM. We have Dr. Kavya Shri Madam from JLC Kolar. We have Dr. Sanjeev Gowda from VB College, Bangalore, and few other resource persons will be joining us, deliberating the topics under the webinar series 2021. And we hope, and we are also committed to deliver a best and effective webinar series in this 2021, which starts from today and goes on till March 10th. And I request all the students to take much benefit out of this webinar series. And I hope all our resource persons, my colleagues, will be more effective and give their best and help the students in this regard. Thank you. And I welcome Atoli sir to take on the session.
Thank you.
Namaskara, sir.
Namaskara, madam. Yeah, namaste, madam. Namaste, madam. Namaste. Okay. Can I make the start?
Tanmay, please share the PPTs.
Yeah, Tanmay, I think Tanmay will do that. Yeah, he's doing.
Yes, sir. Yes, sir.
Yeah, thank you, Tanmay. Good morning, everyone. I am in fact delighted to be with you today for an hour to discuss about this topic, introductory topic in IPR. It is good that you have assigned this topic to me because I worked on this area, and of late, now what is happening is there have been many advancements which are to be covered later. To begin with, what are these IPRs and why we protect them, or why the system protects them, and what are the difficulties in protecting them? These are to be discussed. And from the point of view of students, let me make a beginning by stating that we are here concerned with, in this topic, we are trying to see an overview of the intellectual property, the rationale of protecting them, and the difficulties in protecting them, and ultimately justification for having the system called as IP system. These are certain things to be kept in mind. Are we able to answer these questions or not is your task for the students. So as I said, what are intellectual properties in general terms? Why we need to protect them? How we protect them? What are the difficulties in protecting them? And ultimately, what is the justification for maintaining the system called as IP system? If we answer these questions, I think the purpose of this session will be served. Now, the first question is, what are intellectual property rights? You all have heard to various lectures. You might have read so many things, and you might be knowing what the IPRs now. And for each of the IP, there is definition statutorily and also literally, and also under different judgments. I'm not going into the definition of IP in that way, or definition of any particular IP in that way. My task is to see as to what the IP means for a layman, and how they need protection, why they need protection. To begin with, this topic, human creativity and the importance of the protection. Okay, creation. When we refer to the term creation, it is possible only for the human beings, because humans are described as rational animals. So our rationality inherently makes us capable of creating. Now the next question is, are these creations good? Do they serve any purpose? This is the next question. Now, what we do in daily, see, what we need actually is, we need our well-being. So as humans, we require our well-being. To achieve this well-being, whether we need creations. This is the question to be answered. Now, to answer this question, let me take you to
I think because of low internet connectivity.
Just check. I'll check.
Yeah, I think sir has left.
Some network issue there.
Yeah,
He's back. Sir,
we'll wait.
Sir, Matoli sir, ಕೇಳ್ತಿಲ್ಲ?
Sir, you are on mute, sir.
Sir?
ತನ್ಮಯ್ ನಿಮ್ಗೆ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಲಿಕ್ಕಾದ್ರೆ ಮಾಡಿ.
Ma'am, unmute ಮಾಡಕ್ಕಾಗಲ್ಲ. I can only ask him to unmute. I can just send him a request.
Yeah.
Yes.
I'm here. Am I audible now?
Yes, sir.
Yeah, sir.
Yeah. Because I shifted to the other network. Now I think I'm audible. Yeah. Can I start?
Yes, sir.
Yeah. Sorry for the interruption. It was a network issue here from this place. Now I think that won't happen. Now let me again restart by telling you that we are interested in the well-being of we the humans in the present context, and that requires us to indulge in some sort of research, and that research is nothing but the creativity. So humans need to be continuously creative to achieve this well-being for the present reality. So that is the need. Then we have to be reflective. We have to have open mind. So open-mindedness is the sine qua non for. So open-mindedness is the sine qua non for research. It is sine qua non for the creation or creative mind. So once we understand that the creativity is must, it is important. Now the question is whether we need to protect it, how to protect it, and if we protect it, what are the dangers out of it? That we need to consider at this stage. Now, what happens in intellectual property? Because intellectual properties are the results of creative mind, creation, research. So protection of application of ideas. So when new ideas come, and if they are tried to be applied, and if there is new information, and if that is put into the commercial activity, and this sort of activity needs protection under the head intellectual property. So that is the need of the R. Now, this IP branch, intellectual property, is a branch of law which protects some finer manifestations of human achievement. I said, what is research? A sort of reflection. What is reflection? An open-minded person pursues problems and solutions, and he also pursues problems and new solutions, and these new solutions makes our well-being up to date. So see, whenever people think of the new solutions to the old problems, there is always the finer manifestations, and the human beings excel. So this is called as finer manifestations of human achievement, and they are protected under the head intellectual property. Now, intellectual property is also a fashionable description of research results, because whenever research happens, it gives results, and we ascribe some fashionable notions to such things. That is how we always think of patents, copyrights, trademarks, and other things we always refer to in our day-to-day life. That has become a fashionable trend to refer to the intellectual property. Now, every creation may not become intellectual property, because the law relating to intellectual property do not consider it as worth protection, every creation. Only those creations which fulfill the statutory criteria, they become intellectual property. So that we will see in the subsequent analysis. This protection of intellectual property, I said intellectual property needs protection. If we protect intellectual property, it may create some dangers, which I will be telling you later. What to do then? the protection of IP must be in proportion to their desirability in the sense, to the extent to which the particular intellectual property is important to the society, to that extent there has to be protection of it. There shall not be the disproportionate protection to the intellectual property. So that is what the IP law takes care of. Now, what IP connotes is, it says there is some legal conduct which may not be pursued by the third person. Means only a right holder can pursue a particular conduct, not the third person. This is facilitated by the intellectual property regime, IP regime. So one thing, we have different intellectual property. We have patents, we have trademarks, copyrights, geographical indications, and then we have industrial designs. We have all these intellectual properties. The number is growing. All these intellectual properties are studied under one banner, that is intellectual property. There is one basic objection, that some of these IPs are not intellectual in their nature, in their origin. For example, trademark. Vadilal ice cream, for example, a person by surname Vadilal, he has used that on his ice cream, and even now that is the trademark. There may not be any intelligence in such trademark, but still that is protected under the intellectual property. So they are more industrial property than the intellectual property. This objection is always there, but for the convenience, and also it is internationally accepted practice that all these properties are called as intellectual property. So we go by the name intellectual property. There is increasing economic significance for all the intellectual properties, and the specializations are growing because people are getting specialized in patents, people are getting specialized in trademarks. So there are increasing specializations. Now, I said all the intellectual properties are studied under only one head, that is intellectual property, because of two reasons. Though each of the intellectual property differs from the other in detail. So the reasons for studying all the intellectual properties under the one head, they are two. One is enforcement methods are same. Whether it is patent, trademark, or any other thing, how to enforce these rights, the procedure is same. That is how they are studied under the one head, by and large, internationally. Then second reason as to why these are protected under the same head, intellectual properties, all these properties are called as property intangible movables. So it means, tangible means they are corporeal. We can touch and feel them. Whatever rights we have in intangible movables, all those rights we can enjoy even in intangible concept, intellectual property. That is the reason as to why we are having a common name, that is intellectual property rights. Then my next slide, please. Okay, now let me take you to the conceptual analysis of intellectual property for a very short time. See, in jurisprudence, we study certain concepts: titles, ownership, rights, property. These are the four concepts we study in this jurisprudence. When we study vestitive facts, all these four concepts are interrelated. How they are interrelated? For example, if I own a property, for example, I own a piece of land. I own a piece of land because I have purchased it. Okay. Now, what is its vestitive fact? The fact that I purchased is vestitive fact because that right has vested in me. Ownership. Because of the vestitive fact, I got a title over it, so I am the owner of it. When I am the owner of it, I have rights over the piece of land. I can construct house, I can sell it, I can do whatever I want on that piece of land. These are my rights. So whatever rights I have on that piece of land, together, bundle of rights, it is called as my property. So these are the concepts of the property, ownership, rights, and all. All these four facts do hold good in respect of our intellectual property rights. How they hold good? Why we call them as intellectual property rights? Leave apart the term intellectual, concentrate on property, concentrate on rights. property. I said, property consists in stating that I have rights over something. So it's a triangle. There is a person, there is an object, and on that object, there are rights to that person. There is a triangle. So here, in case of intellectual property, a person creates, a person invents, he gets patent rights. When he invents or creates, the invention which he has made, the research which he has carried out, that is a vestitive fact. Because of that, he gets his inventions registered as patent, that is his ownership. He is the owner of patent. Because of the fact that he is the owner of that patent, he has rights to exclude others from using that invention. That is his right. Together, his right to exclude others, ancillarily, his right to use his invention, it is called as his property. So, it is quite right that we refer to these intellectual properties as property rights, because this is property, these are rights. Rights because right is nothing but an interest recognized and protected by law. In case of intellectual property also, the invention or a literary work, whatever design, that is an interest that is recognized by law when I fulfill some conditions, and that is protected by law because I can seek infringement actions when there are infringements. So there is recognition and protection of interest. In that way, they are rights. So that is ownership, that is property, there are rights. So intellectual property rights are, jurisprudentially speaking, they are justified as rights, they are justified as property. And in terms of Salmon, more appropriately, they are rights in re propria in immaterial things. In re propria means property rights. Intellectual property rights are the property rights in immaterial things. He is referring to the incorporeal things or intangible things. He refers to it as immaterial things. So immaterial things are maybe the goodwill, according to him, maybe goodwill, patents, trademarks, and also this copyrights. These are immaterial things in Salmon's sense. Then these immaterial things are the products of human skill and labor. When they are the products of human skill and labor, they are subject to the property law. In modern law, every man owns what he creates. Now, the traditional notion of property has changed drastically, and now the man is able to own whatever that he creates. So in that way, we have to have the attention on this kind of intellectual property. On my next slide, please. Okay, now let me take you people to this essential nature of intellectual property. What exactly is the distinguishing feature of this intellectual property? I said intellectual properties are nothing but the commercial ideas and informations that are being exploited. And these intellectual properties are essentially negative in nature. What I am trying to say here is, if I have registered my invention as patent and if the patent rights are given to me, what is my right? My right is to exclude others from using my invention. In other words, I have the right in rem against the whole world, seeking that nobody can use my invention. So it is a negative right because I can prevent others from using my patent right. That is a negative right. So essentially, they are negative. Not that the patent holder cannot use his patent to produce goods and services. No doubt. He can use his patent to produce goods and services, but that is the ancillary thing. Not that important for the purpose of IP design, as we understand legally. More important right under the intellectual property is the negative right, which the IP holder possesses. That is very important. That is how in IP, the stop piracy is the main motto of the IP holder or the right holder. So he is more interested, more concerned about the pirates or piracies. Then every intellectual property can be explored only under a license because a right holder can use it. If others want to explore this IP, then necessarily they should possess or have license or permission from the right holder. Then this intellectual properties, each IP has a distinct subject matter and each intellectual property has different objectives. This is very crucial for the beginners in intellectual property rights. So we call, for the purpose of convenience, I take only these three basic intellectual properties: patents, copyrights, and trademarks. For the purpose of convenience, I say these three intellectual properties are such that each of them protects different subject matter and each of them has different objectives. How? I'll try to demonstrate. See, we have patents. Why we give protection? Behind each intellectual property protection, there is what we call as quid pro quo, something in consideration. When IP rights are granted on a person, a limited monopoly is conferred on him. He can use his right to the exclusion of others. He can enjoy monopoly. So a return is given to the creator. In return, what he has given is, he has given up his invention. Because one thing is, his invention is available to the public for the public inspection, but they can't use it. They can enter into further research. This is one advantage. Number two, after the statutory period of 20 years, the invention is available for the open public. Anybody can use it free of any cost or free of any permission. So in that way, there is public contribution from the inventor. So inventor contributes to the public interest, and when he is contributing to the public interest, something has to be given to him. That is how limited monopoly is conferred on him for 20 years to use that right in exclusion. So this is quid pro quo in intellectual property. If take this simple example of the tenure of protection. In respect of patents, I said 20 years is the period of protection. In respect of trademarks, it is 10 years, subject to renewal for another 10 years, provided the user of the trademark, proprietor of the trademark shows that he is continuously using that mark on his products. So 10 years is the period. So patents 20 years, trademarks 10 years, copyrights till 50 years, that is till the death of the copyright owner plus 50 years, we say 50 to 60, because for different copyrights there are different terms. Generally speaking, till the death of the right holder plus 50 years, even his heirs can enjoy the copyright. So a very larger period of protection is given in respect of copyright. Why this discrimination of tenure? It is because, again, you can verify the contribution of person. There is a divergence, there is a difference in the extent to which the person contributes in terms of public interest. What is his individual contribution? What is the societal contribution? There we have to understand. For example, in respect of patents, 20 years period is given compared to trademarks, because there is more intellectual exertion in patents, because there are inventions, people indulge in research. But in case respect of trademarks, there is not big research. Might be accidentally he is using that mark, might be he has established that mark in the business over the period of time. So there is no much intelligence as such compared to the case in invention. So a period of 10 years is enough in trademarks, but a larger period of 20 years is suitable in respect of patents. A justification, different justification is given for different period. Now coming to the copyright, a very large period is given, because even after the death of the right holder, 50 years is the period granted, because the reason is we have to look to the contribution of the individual. When a person indulges in invention, it is not only he who is indulging in research, he needs infrastructure, he needs education, he needs training. Society has given all those things. His family has contributed, his society has contributed. So there is public contribution in his invention also. So we reduce the period to 20 years, not the life period at all. Because of that, it is 20 years and not life period or 50 years as in case of copyright. In trademarks, as I said, there is not even more intellectual exertion, so 10 years is enough in copyright. There's a trademark. If you come to copyright, whether society's contribution is more or individual's contribution is more. So undoubtedly, in respect of literary works and the dominant positions of the copyrighted works, individual contribution is more compared to the societal contribution, because we are able to see that there are great many literary works from the persons who were not literates also. It means even though the family was not contributing, even though the society was not contributing, people may be able to produce literary works. That is how individual contribution is more, so larger period. In that way, see, the periods are discriminated, or different periods are being justified. This is, I said, because each of the intellectual property has to be protected on different footings. There are different rationales, there are different objectives of protection. So we can't have the uniform policy of protecting each of the intellectual properties rights. That is how there are different statutes dealing with different intellectual properties. Though we study all these intellectual properties under the same head, for each of the intellectual property, there is a separate legislation. For example, for trademark, we have a legislation. For patents, we have a legislation. For geographical indications, we have a separate legislation. So copyrights, we have a separate legislation. So, and for many creations or intellectual properties, we are not yet having legislations also, and we are depending on the court, the judicial laws. So this is how there is a difference in respect of each of the intellectual property rights. And for this reason, each of the intellectual property is described as a statutory right, and people can explore and exercise these rights territorially. So they are statutory in nature, they are territorial in nature. Then my next slide, please. Now, some implications of I said the intellectual properties are essentially negative. And what are the implications of this negative rights? These are having great policy implications. So that's how we have to answer some questions here. Legal protection varies according to the different subject matter, I said. While protecting each of the intellectual property, the legal system has to answer some basic questions, or it has to make some basic decisions. What are those basic decisions? What type of subject matter? A subject matter which is suitable to the patent may not be suitable for copyright. That's how there was a great amount of controversy whether the computer software is to be regarded as a copyright or a patent until very recently. So this is how, this is a great policy decision, and that has to be taken up by the legislators only. Then another thing is protection only on application or what? It means whether the IP protection can be given only when there is an application by the right holder or not. And this decision has also to be made, because for example, in case of patents, protection is given only when an application is made and a patent is granted, not otherwise. But in respect of trademarks, protection is of course given when there is an application, registration and all. But even if there is no registration, some sort of protection is granted under the head passing off. And more particularly the copyright, protection of copyrights is possible even without registration. That's how there may not be any application also. That is how even if a person has written a book, he has not published it, nobody can steal and publish it. But this cannot happen in case of invention, because if I have invented something and if I keep it secret, and if somebody steals and publishes it and uses, I can't object unless I get it registered. But such a registration is not necessary in case of copyright. That is how we are to have different policy objectives, because I said individual contribution is more, individual liberty is more important. That's how we give larger protection to the copyrighted materials. Then this is one question. Then another thing is protection how long? What sort of tenure is there for protection? Because we can't have the uniform tenure or the period of protection for different IPs. This must vary because of various considerations which I discussed. Then right only against the imitators or full monopoly. Means should it be absolute monopoly, or should it come into picture only when there is an imitation or infringement? So this is again those copyrights and all, we have to answer those things. Each IP calls for different balance of public and private interest, because public and private interests operate at different levels in each of the IPs. So there is a need for separate legislation because of these things. That is how decisions are to be made politically. Because of the requirement of political decision in IP arena, we have to have these rights on statute basis. That's how intellectual properties are statutory rights. So statutes, because politicians, legislators are politicians, so they make the legislation. Why we have to have these laws statutorily? Because one thing is intellectual property is such a complicated area that it requires special rules, specialized rules. That's how we have to have statutes. And another thing is there has to be the representation of interest groups, because there are traders, there are consumers, public lot. So all these groups have to be represented particularly in the legislatures, and accordingly the decisions have to be taken. So the rights must be statutory. So next slide, please, Tanmay. Tanmay, next slide. Now, next thing to be considered here is legal structure governing IPRs across the world. What sort of legal structure we have? I said prominently all intellectual properties are statutory in nature. Statutory protection is there. But apart from statute, even before this statutory exercise and even after this statutory exercise, courts are contributing manifestly in the protection of intellectual property. That is how we have got a separate branch of law in law of torts, that is passing of actions. And breach of confidence, this is another branch of law which is growing, because it is again judicial contribution. Then misappropriation doctrine, unjust enrichment. These are all the contributions of the courts apart from the statute. This is the legal regime in which the IP works. Then all importantly, the technology is inherently growing. This enhanced technology creates strain on legal systems in protecting intellectual property. So an invention which is a possibility after 3 to 4 years may be copied in few seconds. This is possible because of the advancement in technology. So advancement in science and technology, research and development, it has made possible many creations, but it has also made possible the copying or piracies. So intellectual property protection law has to deal not only with the protection, but also to prevent these piracies. So there is a continuous strain on the legal system to prevent the infringement. This is the challenge of protecting the intellectual property for the systems. Because of this, internationally, this fact has been recognized. Accordingly, we got to establish this WIPO, World Intellectual Property Organization. Then we started out from 1947, that's Uruguay round in GATT, and we reached 1995 January 1, WTO, World Trade Organization, under which TRIPS operates. So under TRIPS, we are trying to give protection to the intellectual properties internationally and also within the national jurisdictions. Then apart from these international instruments, we have judicial precedents within the national systems. We have human rights instruments under which these intellectual property rights are being protected and also being challenged, because some of the cultural rights include these copyrights under the human rights guard. And many patent rights have been challenged as violative of human rights. So the human rights law has also been possible for the scrutiny of this intellectual property rights. Then the intellectual property rights are the territorial in nature, as I said, and that's how there is need for statutes for each of the intellectual property rights. Next slide, Tanmay. Now, the next question for me to deal with is this justification of intellectual property rights. Why we need to retain a system called as intellectual property rights? How we can justify them? There are for the students some theories of intellectual property. I'll be telling them very briefly. You can read them also. But my task here is to discuss at length, in the sense, discuss in a different way as to why we should retain this justification model for intellectual property rights. Intellectual properties are constantly destabilized by technological advance, I said. IP system needs to be retained, and the legal system needs to be concretized and updated, because as and when there is technological advancement, there is continuous infringement of intellectual property also, because piracy gets increased. So this is another justification as to why we should have the strong IP system. And another thing is, Intellectual properties are the result of idealistic and utilitarian perceptions. It means when a person writes a book, or when a person makes a speech, or when a person does something intellectually, he is ideal, he is creative, he is expressive, he is a role model for others in the society. So such persons we should encourage. That is how there is some idealistic value in intellectual property. Utilitarian perception. When inventions are made, when designs are made, when trademarks are evolved, there is benefit for the consumers, there is benefit for the society. So there is utilitarian perception. That's how we have to protect these intellectual property rights. All importantly, intellectual properties are having aesthetic and cultural values also. Aesthetic. I don't know whether I'll be earning profit or not. I want to write a book. Whether I'll be my books will be having readers or not. I want to write a book. I write it. This is my aesthetic experience. I like something, I do it. And this kind of urge for the individuals must be protected by the system. And system must have laws for such urges in the individuals. And that is the natural law requirement for the legal system. And that is facilitated by the intellectual property system. Cultural value. When I produce copyrighted works, it contributes to the culture of the society. So that is another reason for justification. Then, all importantly, intellectual properties are the incentives to produce, because you can have efficiency in cost. So with that, there will be economic expansion, and with that, there will be increased consumer choice and consumer welfare. This is how there has to be protection. Then, all importantly, legal system is interested in preventing unjust enrichment. So a person should not reap something when he has not sown the seeds. So no harvesting without sowing. So if I have not done something, I should not reap the fruits of somebody else's labor. So that is another thing which is to be taken care of, and that is taken care of under the IP system. And this justification or this kind of protection to intellectual property has met with two challenges at the international level and also at the national level. And these two challenges are, first of all, there is a sort of political challenge to the IP protection. What is this political challenge? When intellectual property rights are guaranteed across the world, internationally, under the garb of free trade, liberalization, globalization, and privatization, then what happens is the economies of underdeveloped countries and developing countries are quite open to the world. And because of the lack of competition, the firms may suffer and they may get closed in developing and underdeveloped countries, and the firms of the developed countries may flourish. This is what can happen. And because of this IP system at the international level, the developing countries started exercising protectionist policy. So they started protecting their domestic industries. And this was objected to by the developed countries. And by 2005, under the WTO norms, everything was to be mandatorily kept open, and accordingly, the economy is quite open now. So we have got open economy. This is one challenge which is faced by the IP system across the world from the point of view of both developed and developing countries. Then the another challenge from developed countries' perspective is they are having good IP system, industrially developed countries, no doubt. But the problem is these firms which are enjoying monopoly rights in IP may become dominant, they become monopoly, they exert more monopoly, they make more profit, and accordingly they may abuse their monopoly power. And this has also become the challenge, and as part of WTO deliberations, it was necessary to evolve antitrust laws. So accordingly, developed countries had to have these antitrust laws, and accordingly, antitrust laws are the part of developed countries. But ironically, the same antitrust law, which has been part and parcel of systems like England and America, has become part and parcel of the systems like India also. Because we had the MRTP Act 1969, wherein public interest was playing a pivotal role. But when we look to the Competition Act 2002, there is not even a single word in the entire legislation, public interest. So public interest has been taken away. So there is least care for the public interest. I don't know what sort of interest it is being protected, whether in the name of protecting competition and encouraging efficiency, the public interest is diluted in countries like India, especially the developing countries. This is the challenge faced by the developing countries, especially because of this intellectual property. Now, go to the next slide, Tanmay. Now, let me very briefly go through the theories of intellectual property rights. Natural rights theory. Natural rights theory, see, natural law. What is natural law? Natural law is nothing but the set of objective moral principles derived from human reasoning. Humans develop their reasoning as per the rules of nature. So, what is good and what is bad is basically known to the humans. These are the presumptions of natural law theory. With those presumptions, what are natural rights then? One of the important natural rights is when a person produces something out of his labor, whether mental or physical, the fruits of that labor must go to that man only and to none else. This is very natural right. So a person has a natural right to claim the fruits of his labor. So such a guarantee can be given under the IP protection. So this intellectual property is first of all supported by the natural rights theory. But one thing, there is an objection that it is not always that the individuals act according to the natural rights. It is not always that they act according to the well-being of themselves. So the persons may act against themselves. These are certain inherent defects within the natural law theory, and they hold good even in respect of intellectual property rights. Second theory is utilitarian theory. When person creates something or invents something, he is contributing something to the society which is very useful. So accordingly, quid pro quo, something has to be given back to him. So utilitarian theory is there. Again, this theory also has certain drawbacks because you have to be very subjective in analyzing what are the utilities and what are not the utilities. Again, you have to be very subjective in estimating the problems of monopoly. So these are the problems with utilitarian theory. Then the ethics and reward theory. Ethics and reward theory means I shall not reap the fruits of other man's labor. This I already said. And reward, when somebody has done something which is appreciable, we should reward him with something so that he will come forward to invent more and more, create more and more. That is possible only when there is ethics. Ethics necessitates the reward policy or reward theory. Then personhood theory. Personhood theory means when I create something, whatever I create is a part of my personality and that should be protected. Suppose I write a book. And if someone else alters my book without my consent, he is affecting my personality. This is more suitable to the copyrights. This personhood theory is more suitable to the copyrights and it cannot be suitable to the other kinds of intellectual property rights. So this is fourth theory. The fifth theory, this is economic theory, which is the mixture of all these theories. And also I have clubbed here the separate theory of IPRs, which is a peculiar combination of all these theories. And this I'll be discussing for 5 minutes with you people. This next slide, Tanmay. In this theory, the economic approaches to the protection I'm discussing, what happens is, for intellectual property rights, we are giving property rights. Because of property rights, what has been made possible is the legal exclusivity. It means a person who is owning intellectual property can exclude others from using his right without his consent or permission or license. This is the first thing we have ensured. This is because he has contributed to the society because of his creation. And we have conferred private ownership on that person, on that property. Private ownership and legal exclusivity enriches or increases efficiency. Private ownership always increases efficiency. This we have found in the very theories of the economics, that is the capitalistic economy, that individualism, what we call as. The idea of tangible movable property. The idea of tangible movable property means, suppose I have a bike, I have a car, I have some gold. These are my tangible movable properties. I can pledge these, I can sell these, I can assign these, I can do various things like that. All these activities I can do with the intellectual properties also. That's how there is a private ownership for these properties. Then these properties are undivided and absolute, in the sense, when I get patent right, I am the monopoly of it. Exclusively, I own it. I am the absolute owner of it. This enhances efficiency. And because of this, there is need for some theoretical adjustments in the jurisprudence. Because no right can be absolute. There have to be impediments. There have to be restrictions. Accordingly, there is need for some theoretical adjustment. And we should also think in a system whether imitation is cheap or innovation is cheap. Because if there is no IP protection and if the laws are not there, imitation is very easy. People start imitating than inventing. If there is a strong IP system, costs of imitations are very costly, and there may not be imitation because there may be litigation. So imitation versus innovation is another policy matter to be decided by the system. Then, all importantly, intellectual property system is dealing with the unfair competition. What is this unfair competition? If I have invented something and if I am producing the goods, if someone else is using my invention without my permission and producing the same goods, he is unfairly competing with me. This should be prevented. This sort of unfair competition can be prevented with a solid IP protection or IP system. Next slide, Tanmay. Okay, now the next area. What is monopoly? We know it from the basics of economics that when a trader is able to control his supply, he is able to control the price. If he supplies less, the price for his product will increase in the market, so his profit margin will also be increased. He is called as monopoly. And whether the IPR's result is in monopoly, this is the question. If I invent something and if I am able to produce a new good on my own and nobody can produce that good, then I am the monopoly over that good. If I want to reap more profits, I can reduce supply and see that the price is increased, I can increase the profit. Yes, theoretically this is possible in respect of intellectual property. But practically this is not so. Because when an IP holder tries to behave as a monopolist, it is quite possible that the consumer may shift their spending from his products to the products of someone else. So this is the threat faced by every trader. Then another thing is, in our day-to-day system at present, what is reality is not the monopoly but monopolistic competition. Monopolistic competition means we see in monopoly what happens is trader is single, buyers are more. But in respect of monopolistic competition, traders are also more. Products are also, the product difference is the hallmark of today's market now. So if a monopolist increases the price of each product, for example, if MI or Samsung increase their mobile prices exorbitantly, then the people will definitely shift over to the other mobiles, though they are having patent rights over their inventions and all. So because of this, the monopoly as we perceive in economics is not a reality in respect of intellectual property rights. So what is reality is, in respect of intellectual properties, there is what we call as limited monopoly. This is not the full-fledged monopoly, it's a limited monopoly, it is a subjective monopoly, it is a regulated monopoly. Where is the regulation then? Statutes. The statutes which guarantee, which protect, which ensure the protection of intellectual properties, the same statutes regulate their use also. The same statutes provide for the prevention of their misuse also, the abuse also. For example, we have got provisions regarding the government use of patents. We have provisions regarding the compulsory licensing of patents. For example, Novartis, anti-cancer drug. when its price was exorbitantly put high, the system didn't sit silently, and the government issued compulsory license ultimately, and it's successful also. So what we see here is the monopoly as such, we discuss in pure economics, is not a possibility in respect of intellectual property rights. So this is how this monopoly behavior is not a reality in respect of intellectual property rights. Next slide. The presumption against monopoly. Okay. One thing, monopoly is basically bad. It's not a good idea. But when it is operated into a limited extent in intellectual property regime, it is not a harm compared to the benefits which it is ensuing. This is my submission here. See, in case of monopoly, what happens is there is misallocation of resources. For example, when the price of a particular product is kept very high, people will start putting their resources into some other product, even if they don't want it. For example, a family is deciding to purchase a television set next month. So it has kept some 30,000 rupees for the television set. It has kept 30,000 rupees. And in the meantime, what happens is the government has increased the tax rates, and according to the television, the 30,000 rupees television has become now 40,000 rupees, or monopoly has increased the price. Now the price of the television set has become 40,000 instead of 30,000 rupees. So there what happens, the family may decide, okay, let us go for some second-hand vehicle this month. Let us allocate this resource to the second-hand bike instead of television set. So this is how people wanted television set. Now they are putting their resources into the second-hand bike. So this is called as misallocation of resources. These things are not at all good for the healthy economy. So this is the problem with the monopoly. And whenever any IP monopoly increases price exorbitantly, this kind of misallocation of resources can also happen. So the systems regulate intellectual property for that reason. Then another thing is, whatever might be the extent, intellectual properties, they result in some monopoly, and monopoly to any extent, it can result in unjustifiable redistribution of wealth. It means poor may become poorer and rich may become richer. This was the old concept, but now also it is happening because few are becoming rich. They may be the multinational companies. They may not exactly be some business people, but they may be multinational companies. So this is another thing. And the important thing or important danger with the IP monopoly at present is the deleterious effects. What is happening with the IP monopolies is they are enjoying the monopoly not only with the goods produced out of the intellectual property, they are also giving some deleterious effects. For example, these Hyundai, Maruti, whatever, these companies, they exercise their monopoly not only while selling the cars and vehicles, they also extend their monopoly to the after sale service also. For example, even after the sale, you have to come to we people only for service. You have to pay this. They make it compulsory or mandatory. So this is how these are the deleterious effects affecting the consumer interests because of the IP monopoly. Now, one important thing is when there is IP monopoly, there may be disincentive to keep down the cost, and accordingly there may be less research, so the cost may increase, prices may increase, inefficiency may increase. This is possible. Then despite all these problems, there is one chief advantage with the intellectual property, that is economies of scale. Means when there is IP monopoly, single trader, the quantum of production is large. As the quantum of production is large, the costs become less. Under the theories of economics, economies of scales or cost economies we describe. So that because of that, there is cost efficiency. That is an advantage. And whatever, in respect of this intellectual property, whenever there is monopoly, the WTO has provided a mechanism called as the antitrust law, and all nations, member nations of the WTO, have to ensure that there is in their statute book a law called competition law, and accordingly we have the Competition Act 2002 in India. Whether it is able to serve its purpose or not is different question, but there is law to protect to mitigate the abuse of intellectual property law. Then next slide, please. Okay, this is my last slide, in fact, before I wind up. I'm just here concluding the desirability of the intellectual property despite these monopoly elements or despite these dangers in the IP regime. I'm just justifying the IP regime despite all these things. First thing is, intellectual property relates to the exclusive right to perform some defined activity. Means, despite this monopoly, IP has to be retained because it is giving monopoly to act in some defined activity only and not in all the activities. One thing. And another thing is, ultimately the governments are left with some discretion and powers to prevent the abuse of the monopoly. Secondly, ability to exert monopoly power within a market is an assumption than a reality in actual practice, because the actual market is characterized by the existence of substitutes and availability of alternatives. As I said, if one brand of mobile increases its price, then people will easily shift to the other brand. So there are substitutes, there are alternatives, monopolistic competition. So that is how IP monopoly is not dangerous. Then monopoly power is difficult to determine, because when we say that people go in for a particular brand, they go for that brand not because of its price or something else, because they go for that brand because of the technical advancement in that, new features in that, new fashions, then repeated advertisements, then the price. So price is not the ultimate criterion in deciding the purchase in respect of IP protected goods. That is how we need not worry about the IP monopoly in actual practice at present. So anyway, ascertainment of the monopoly element in IP sector is a very complex issue, and this cannot be overdone, or the IP monopoly itself cannot be overdone if there are abuses from time to time. Only thing is we should regulate them, and there shall be litigations, there shall be resolutions of the disputes, and ultimately what has been the reality in respect of intellectual property is not an absolute monopoly, but a limited monopoly. So with all these things, what we can say is human creativity is a must for human advancement, optimization of the human welfare. So creativity is sine qua non. To ensure this creativity, there has to be legal protection for the creativity in the form of intellectual property. And there is also a side effect that with that kind of legal protection, there may be abuse of such monopoly power or whatever. And to prevent that abuse or misuse and non-use also, that is also very dangerous. And there has to be a legal system, and that is part and that should be part and parcel of the intellectual property laws. And that has been the case so far. So there is monopoly, there is legal regulation of the monopoly. So with all these, the intellectual property regime is working at an optimum level, and the working of intellectual property to subserve the human good is a continuous process, and the legal system has to serve this purpose. So with these words, I am concluding my presentation. I am open for questions now. And before I keep myself open for the questions, I thank the organizers, Principal J. Mallikarjunia, Rasmi Madam, Anita Madam, Tanmay, Manoj, and all my friends in KLE. And I particularly thank the students of KLE and also the others who have joined this webinar. And I wish all the best to you in further series or in this series. Thank you. Thank you very much.
Now it's time for question and answer. And I request the students to post their questions and also to clear the doubts with respect to answering the examinations also. If you have any queries with respect to the questions, particularly asked during your exams, you can just post it to sir. Sir will definitely help you out in giving you at least a scheme of answers. What is the right way of answering or approaching the question in the examination?
Madam, you can take those questions and ask me briefly, no issues. You read those questions, you can ask me. You can put them to me in a nutshell. I can answer them.
Yeah, I think the questions can be posted in the chat box. So can we permit them to ask orally individually, sir?
Please, please, let them come on screen and ask, no issues.
Okay.
Ma'am, I have enabled them to,
Okay.
yes. So there is, I once again appeal to all the participants, if you have any questions to be posed to the resource person, please either raise your hand so that I can allow you, or you can do it on your own by unmuting yourself.
Yeah, there is a question in the chat box. How is
Yeah,
monopoly IP balanced with other factors like public interest?
Okay. I said that this IP, this monopoly itself is against the public interest. It is presumed to be causing harm to the public interest because public are interested in getting the goods at a lower price, but the monopoly enables the trader to sell the goods at a higher price. So there is a dichotomy. Basically, there is a dichotomy between public interest and the monopoly. And is this monopoly a reality in respect of intellectual property? I answered, I told you that the monopoly, as we realize in basic economics, is not a reality in respect of intellectual property. First of all, there are regulations, one thing, so no need to worry. So in public interest is taken care of by the individual statutes dealing with intellectual property. So no intellectual property is causing harm to the public interest. In that way, a sort of mechanism is ensured in each and every statute relating to the IP. And another thing is, in practice, people are not that much bothered about the prices nowadays. So it is the very concept of public interest has become diluted. So it is, I think, very difficult to gauge the extent of public interest. When it is difficult to gauge the extent of public interest, I think it is very difficult to answer that question also. Next question, please.
Sir, many times during valuation, what I've observed in paper one is the students always get confused with patents and copyrights.
Yes, yes.
I have seen most of them writing, using the word copyrights in place of patents and writing trademarks also in place of patents.
Yes.
I don't know why they get confused. So it is, though it is very clear.
It is clear, madam. Problem is, see, when I think students are also there in this webinar, I use my words cautiously. If any particular student, because I cannot say it with respect to each and every student, if any particular student has got confused with the copyright with patent and all, he is acting like a layman because people call it. So when I say that people refer to copyrighted works as patented works and patented works as copyrighted works. For example, a friend of mine who is an economics professor, the other day he was telling, he was asking me over phone, can I get patent to my book? So he has written a book. Can I get a patent right over this book? This was his question. So I explained him, no problem, because I don't blame him because he is not a lawman. So he is a layman. I explained him. But if our students do it, they are laymen. So with much respect to the students community, I say that you have to be very particular and you have to understand the basic difference between patents and copyrights and trademarks, especially these three, try to understand. That's how I said each of the intellectual property is protecting different kind of subject matter. In patents, what is protected is invention. In copyright, what is protected is there is a subject matter which is protected specifically in literary work, cinematograph films, artworks, so the dramatic work, all special categories there. When it is trademark, what is protected is a trade, that is a mark or a symbol or a trade name. So the different subject matters are protected and the objectives are different, method of protection is different. So students must be aware of those things. And if the students are writing, or if majority of the students are getting it confused, I think the problem must be lying with we, the teachers, in my opinion.
Ma'am, you're on mute. Ma'am, you're on mute.
Thank you. Thank you, sir. Any other questions? I think the lecture is very clear and most of the questions are cleared. Yes, now it's a time to propose a vote of thanks. And I request Varun, faculty, and also a member of our Navodbhav IPR cell to deliver the vote of thanks.
Okay, thank you one and all. I'm muting myself.
It's an honor to present vote of thanks on this special occasion. Firstly, on behalf of all of us, I would like to thank the honorable and respected resource person of the day, Dr. M.K. Matoli, sir. Thank you, sir, for enlightening us with various aspects of IPR. Indeed, it was a very valuable experience and student-centric. Thank you, sir. I would now like to thank Principal Dr. J. Mallikarjunaiah, sir, Academic Coordinator Dr. Anita Madam, IQSC Coordinator Dr. Manoj Hiremat, sir, and all the faculty members for their constant support. I thank you one and all. I also thank all the participants here, and I would also like to thank Tanmay Patil for his technical support on this Zoom platform. Last but not the least, I thank Navodbhava, the IPR cell, faculty coordinator, Madam Rashmi, Madam Simona, and all the student members of IPR cell. I thank you one and all for joining this session. Have a good day.
We exit an announcement to you, to all the participants, that tomorrow we have another session, the second session of the webinar series by Dr. Pramad Tadika, sir, on the topic traditional knowledge and patent issues, case study analysis. It would be a very effective session with the case study analysis, and I request all the participants to log in at the same time by 10:50. The Zoom link will be shared in some time soon. And kindly fill the feedback form for further improvements of the sessions. Thank you so much. Thank you, Matoli, sir. Sir.
Just a minute. Thank you.
Oh,
Thank
sir
you
is
very
here.
much.
Thank you, Matuli sir. Thank you.
Thank you very much. Thank you very much.